Anthony for breakfast, Albany 783 Triple M. Well, most workers are employed in the National Employment Relations System, and in the last few months there have been a number of changes with a number of additional changes on the horizon that employers and workers need to be mindful of. We're catching up with HR expert Jonathan Wolfrey. Thanks for your time, Jonathan.
No worries, Anthony. My pleasure.
Now, can you remind us of what some of the key changes have been from an industrial relations perspective so far under the Labor government?
Yeah, for sure, Anthony. It's been a busy time for those working in this space, more so than any of us can remember. The Labor government been out of government in the federal system for quite some period of time and have come in with some real specific priorities that they've pushed in their time in government so far. So, and just on top of that, since the last time we did have a Labor government, we know that more and more things roll up into the national system. You know, the Great Southern used to be under the state system many years ago, and we used to look more locally for the input and things. But all these decisions being made essentially in Canberra on our behalf are filtering their way through and impact everyone, including in the Great Southern. So some of the things that have started early with a quick legislative agenda were around sexual harassment elements in the workplace. The requirement for employers to be a lot more proactive in the space to prevent sexual harassment. For them to take what we call a positive duty to actually prevent sexual harassment. Don't just respond to complaints, but actually prevent it and do things like that. There's been a lot of work as well put in equal pay. So pay secrecy clauses were in some contracts and in some industries are no longer legal. You're not allowed to require your employees to keep their pay secret. A lot of that was to try and improve equal pay, so that women, particularly in the workforce, could talk about their pay and realise that perhaps there's some issues in regards to their workplace. And the other thing that's really happened pretty quickly, particularly for bigger organisations now, just to caveat, small businesses sometimes have their own little quirks in here where the government try and reduce the onus on them. So family and domestic violence. So there is the requirement now to have 10 days paid, an extra 10 days paid family and domestic violence leave to comply with new legal obligations, etc. So some things to do with sexual harassment, equal pay, family and domestic violence leave, they were the things rushed through really quickly, are in effect now.
So, Jonathan, what are some of the changes potentially on the horizon?
All right. The changes on the horizon are going to be bigger and bolder than the ones I've already mentioned. And there's some on the horizon that have already been legislated that they're now just transitioning to. And there's some that are on the government's agenda that haven't been legislated but will come in there. So it's going to be a pretty busy time. Probably what I'd like to tell or assure your listeners are that, a lot of it's technical stuff, which doesn't apply to most employers and workers. It's things about the way that enterprise agreements are registered, etc. But some of the things that will impact people in the workplace is, things around flexible work. So employers now have to respond within 21 days to any request for flexible work, and they have to have good business reasons to do so. Otherwise, it might end up in the Fair Work Commission. So there was always flexible work provisions in legislation and things like that, but now there's a much stronger requirement on employers to consider those with a lot more detail and in a particular way and in a timely fashion. So there's some things that will impact a lot of workplaces. There's other things that are coming up on the horizon to do with fixed-term contracts. So no longer can you have a fixed-term contract that goes beyond 2 years, except in certain circumstances, which is really quite limited. Looking at things such as the definition of casual workers, which has been something on the agenda for some period of time. So, for example, if people are working in regular shifts but listed as casual, there may be some issues and further provisions in legislation upcoming in there. And something that is a bit more technical but that may impact a number of your employers and workers would be changes to enterprise bargaining agreements and how they are negotiated. For example, any employer can be joined in certain circumstances to enterprise agreements for other employers, which is causing a bit of stress to some employers that think they may be automatically shoved with these agreements. Now, there's certain circumstances involved in that, and I know it gets a bit technical, but for those that are under enterprise agreements, there's definitely some things to be mindful of as the legislation changes.
Are there anything that employers and workers should be doing at this stage?
From an employer perspective, it's definitely time to actually make sure you've got your house in order. Look, a lot of these changes do have implementation rules attached to them. There will be some time as employers get used to some of these things. And there are some concerns from some employers in regards to, what changes these are going to force upon them. But what we always recommend to our employers that we work with is just get your house in order. That will prevent a lot of the things. So, look at auditing or looking at your fixed term contracts, look at your casual arrangements, look at any enterprise agreements if you do have any in your workplace. Those big picture terms and conditions, things that exist in all organisations, small and large. So get those in order, know where they're at, have a sense of how they're going to apply to the new legislation. If you're a worker, on the flip side, a lot of these things are designed to benefit workers. So, if you've been on rolling fixed term contracts for a long period of time, or you want to get off casual and get put onto permanent, maybe you can have a look at what in a simple way, what the new provisions might mean for you, and start having those solutions-focused conversations with your employer to say, hey, look, I'm really looking for the opportunity to talk about going permanent or to have my shifts put into stone or things like that, depending on what the circumstances are. So, I think, look, most of the obligation at the moment is on employers to get their house in order. But hopefully for workers particularly, there's opportunities for them to really solidify their employment arrangements and get more secure work out of things moving forward.
HR expert Jonathan Wolfrey, always great to catch up, and we'll do it again soon, Jonathan.
Look forward to it, Anthony. Thank you.